The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Hey, good morning. Thank you very much, Matt. Good morning, Attorneys O'Brien and Strasnick. My name is Ariane Vuono. I'm joined today by Justice William Meade and Justice Catherine Hand. We'll be hearing your case this morning. I think you both know that you each have 15 minutes to present your argument, and there is no rebuttal. I'll keep our fingers crossed that we have no technical issues, but if we do, we can be reassured that our clerk will reappear and help us out, and we can proceed. With that said, Attorney O'Brien, excuse me, let me call the case officially. 2023-P-1207, Simon Allen Wentworth versus WHITCO Properties, LLC. Okay, Attorney O'Brien.
Good morning, panel, and may it please the court. My name is James D. O'Brien, Jr., and I represent the plaintiff appellant, Simon Allen Wentworth. At issue here is not the construction of the purchase and sale agreement, which my client and the defendant appellee signed. Rather, it's the interpretation of its effectiveness after a so-called expiration date passed, and the parties continued to act as if the closing was about to take place. I'm not going to repeat the facts, but as I'm sure the court's aware, there was a problem with an unrecorded discharge of a mortgage, which was an out-of-state company. It took some months to rectify, and that was from October until March. During that time period, again, this is in the record, my client's attorney, Anne Marie Hurley, was in constant and regular contact with attorney Jack Morrison's office with regard to the status of the discharge.
Attorney O'Brien, what role did Attorney Hurley play in the resolution of the unrecorded discharge?
She was original counsel for the transaction, and she basically served as in an advisory capacity for this action.
Okay. So is it fair to? I didn't mean to interrupt. Go ahead, Justice Meade.
No, I'm just gonna the first extension you got from was October 15th to the 22nd of October was in writing and signed by the parties in accordance with paragraph 27, but you never again executed a written agreement to extend, which the judge found, and the judge further found that WHITCO had not waived that requirement.
I would say the course of conduct on the part of WHITCO is just the opposite, that Mr. Whitney did in fact waive the obligations under the extension. And
I guess I phrased my question poorly. I guess my concern is that you've argued this in your brief as if it were a summary judgment motion. Instead, this is a matter that's been tried by a judge, and he made findings of fact, one of which is that WHITCO did not, by its conduct, waive Rule 27 or paragraph 27, and you just say that he has, instead of explaining how the judge's finding is clearly erroneous.
Well, Judge, there was ample testimony that Mr. Whitney gave a power of attorney to his then counsel, Jack Morrison, and had little or nothing to do with what happened in between the original closing date of the 22nd and the securing of the discharge in March of the following year. So I would suggest to the court that Mr. Whitney abdicated his responsibility under paragraph 27. And
the judge got to make credibility determinations. And you have not pointed to anything in the record that makes his finding of fact clearly erroneous. You don't even argue it's clearly erroneous.
Well, it's erroneous based upon the conduct of the parties, and I refer the court to the case of Thomas Schenkel versus Maxey Holdings, 30 Mass Appellate Court 41. In that case, Judge Armstrong found that, bear with me.
He said the parties, but I read it yesterday, like the parties' conduct indicated that they wanted to waive it. But here, the judge found the opposite, and that their conduct did not waive it.
I know that that's what he found, and I don't think it was correct. With all due
I agree with you that parties can waive a requirement in a contract by words and conduct. The judge just found it did not occur here.
Well, I would beg to differ, Your Honor, because doing nothing, as Mr. Whitney did, is in fact conduct that perpetuated my client's thought that this was a deal that was going to go through.
Sorry, go ahead.
Why he didn't, I mean, if he thought that the deal closed on the 22nd of October, and that was the end of it, he then spent the better part of 5 months doing absolutely nothing to effectuate what he claimed was the validity of the October 22nd closing date. And he waited till the very 11th hour after the discharge was finally obtained to then say he didn't want to go through the deal. And I have reasons to understand why that might have occurred, because like in most cities, the value of three-deckers has vastly increased in a short period of time. And I think,
Attorney, sorry.
yeah.
I'm sorry to interrupt you, but when was the first time that WHITCO tendered back the deposit to your client?
I think there's a $9,000 deposit that hasn't been tendered back. As far as I know, that would have been with Ms. Hurley.
Well, there was testimony that it was,
Right.
at least an attempt was made to return the deposit. I believe it was at the time of when counsel for WHITCO said that the deal was not going to go through any longer.
Then why, Your Honor, why did Mr. Whitney allow the search for the discharge of the mortgage to continue? That seems absolutely contrary to somebody who doesn't think the deal was still valid.
I think Mr. Strasnick will probably tell us it's because Mr. Whitney still owned the property and it was still encumbered. And that as far as he's concerned, the contract expired on October 22nd when the parties weren't able to perform.
Again, Your Honor, I refer you to the case that I just pointed out. There's ample discussion in that case with regard to factors that affect the perpetuation of a contract beyond the written form.
Well, let me ask you another question, if I may. Is there anything in the record, not outside the record, but in the record, that explains why it is that the potential buyers, your client's lawyer, was the one spearheading the discharge of this mortgage? It appears to be, anyway, from the testimony, rather than those that were working for the seller.
Your Honor, if you look at the record, and especially in the appendix, there are multiple emails between Attorney Hurley and Mr. Morrison's office, a woman by the name of Melanie Mercer, and she was constantly asking her the status of the search for the discharge. And in fact, she was also working with a local title examiner, Peter Adams, who was attempting to square away the discharge because the discharge kind of came from a bank in Missouri. And so there was ample conduct on the part of many people, including people who were acting on behalf of Mr. Whitney, that suggests that this deal was still alive. And frankly, I don't know how that could not be understood by Mr. Whitney. His paralegal was in direct contact with Miss Hurley. Mr. Whitney had signed a power of attorney to Attorney Morrison. So he lives in Melrose, and he didn't want to be part of the actual closing. So he separated himself from all the activity that dealt with the extension of the facts that went beyond the extension of time of October 22nd.
You also rely on paragraph 4 of the buyer's rider.
Yes, Your Honor, I do.
And the judge found that because there was no time frame or deadline under which it was to be carried out, that it still had to be within a reasonable amount of time. And he said, based on the conduct of the parties and the particulars of the P&S itself, that the 5+ months was not reasonable. Now, again, I that's a finding of fact that you don't argue is clearly erroneous. You just argue that you're right.
No, I think it was erroneous, Judge, because
but you don't argue that in your brief, sir. You just say that paragraph 4 of the buyer's rider allowed them to make it an indefinite closure date.
Again, Your Honor, it's based upon the conduct of the parties that started immediately after the October 22nd date. Nobody was doing anything but trying to get this piece of property closed. And I recognize that 5.5 months is a long time, but why didn't Mr. Whitney make a demand for the closing after that when he knew he got the discharge? It would be easy to throw this back on my clients, Your Honor, but all they did was they did nothing wrong. They wanted to buy this property, and the fact that
well, you didn't get an extension in writing under paragraph 27.
I understand that, Judge, but I'm not a real estate practitioner, but I have handled closings in the past, and it's not unusual for one lawyer to say to another, "Hey, I'm going to get the discharge in a month or so," and leave it at that. And the discharge comes in a month or so, and I recognize this is much longer, but it comes in a month or so, and that's fairly common conduct for lawyers who are doing especially residential real estate closings. There's a lot of flexibility when it comes to buying a house, especially when the lawyers know each other. And so I think Ms. Hurley had every bit of confidence that Mr. Morrison was going to arrange for the securing of the discharge. I admit, first of all, that 5.5 months is a long time. But if you do check the record, you'll see that Ms. Hurley was in constant contact with Attorney Morrison's paralegal all through the 5 months. And the only hint that my clients got, and it wasn't a hint, was when they finally got the discharge, Attorney Morrison says he doesn't want to go on with the deal. The question is, why wasn't that articulated to Attorney Hurley before that date, especially when he had to know his paralegal was working with Attorney Hurley to secure the discharge. I personally, I think this is terribly unfair, Your Honor. I recognize that I recognize in the research I did, there are plenty of reference to the necessity of filing an amendment, a written amendment. However, the case I cited to you, Schenkel versus Maxey Holding, does not necessarily follow that standard. And it says that, the conduct of the parties can be controlling and can amend the written agreement. I don't know what could be more complete than that. My clients had no facts to rely on that this deal was not going to go through.
Okay. Well, thank you very much, Attorney O'Brien. Your time is up. I'll just check with the panel and see if they have any follow-up questions. And I seeing none. Thank you for your argument. We'll turn now and hear from Attorney Strasnick.
Thank you. Good morning, Your Honors. May it please the court. My name is Robert Strasnick. I represent the appellee in this matter. I'd like to start very briefly by just articulating the standard review as to the interpretation of the contract. That would be de novo. As to interpretation and review of the facts of the case, that's a clear error standard, as Your Honors have been mentioning. In this case, there was an extension that was granted, and the language of that is important because it did not reference paragraph 8 of the purchase and sales agreement. It was simply a request to extend, and we know that from paragraph 27, the writings are what controls. Had the parties referenced paragraph 8, which would have provided an automatic right to the seller to extend for purposes of the title issue, buyer would be stuck with that. The rider in paragraph 4 says if the agreement was extended pursuant to paragraph 8, there would be a right to extend on the buyer's part in perpetuity. Now, I'll put aside whether that would be enforceable, but because as an initial matter, the contract was not extended, or performance under the contract was not extended pursuant to paragraph 8, it lapsed on October 22nd, and any right the parties had as of October 22nd were done, and there was no written agreement to put the parties back into contract from that point forward.
Why wasn't the judge's finding that there was no waiver by conduct of the writing requirement, putting aside the rider, but talking just about the P&S? Why wasn't that clearly erroneous where there was evidence in the record that Attorney Hurley catalyzed this search for the mortgage discharge, remained at least in regular contact with the paralegal for Attorney Morrison's office, had conversations with that paralegal late in the game, suggesting that the parties were planning to go forward, and there was no return of the deposit until after the seller recanted once the mortgage discharge was obtained? Why isn't that a waiver by conduct of that writing requirement?
I would say, Your Honor, that there's a few different issues lurking in your question. I think the strongest one for the other side, I have to be candid, would be why didn't the seller offer the deposit back earlier? What I would say in response to that is an act of omission doesn't have an affirmative effect to put parties back into contract when the contract had already expired. Would it have been cleaner? Would it have been more proper? Sure, but I don't think it's outcome determinative, and the trial judge who heard the witnesses in person did not find that that acted as a waiver. The parties did not know when that discharge was outstanding how long it would take. Maybe it would take a week, maybe it would take 2 months, maybe it would take multiple years. These things are not unusual. So the fact that attorneys are trying to chase down a missing discharge without knowing if or when or ever it'll be obtained would not be a reason to keep parties in contract. I'd also point out, as the trial judge found, and as stated in the Millennium case that I had cited and attached to my brief, there still has to be, if there's an extension, a reasonable amount of time for that extension. The judge found that close to half a year is not a reasonable amount of time. And that would be supported by the fact that the seller is carrying the mortgage during that time. Seller's carrying the insurance, sellers bearing the risk of loss for the property, sellers bearing the risk of an increase or decrease in the market. So and that's just by way of example, putting those together, and the judge is finding that it went beyond what a reasonable period of time would be, I don't think that the court could find that his finding was clearly erroneous. May Your Honor have had a different interpretation and think that 5, 6, 7, 8 months or even a year is reasonable? Perhaps, although I don't think that hopefully you would, but in reviewing what the trial judge did, it would be difficult to find those or that decision as being clearly erroneous.
I'm wondering if you could elaborate a little bit on one of your answers to Justice Hand's question, which is zeroing in on the conduct of the parties where both the paralegal was worked with the lawyer representing your client and the attorney for the buyer were working diligently and hand in hand. And yes, you're right. If this had happened in only a month or so, we may not be this case might never have been brought. But they weren't surprised. There was testimony at the trial. They weren't surprised that it would take longer than that because of the fact that they had chased down an out-of-state mortgage holder, etc. Why would people keep working on it if it was never going to be?
Perhaps on the buyer's side, there was a hope that it would be. There'd be an expectation that it would happen sooner rather than later. The requests were already put out for it, and there'd be follow-up. But I need to draw a distinction between extension and formation, because initially, no matter what their conduct was, as of October 22nd, there was no contract. So no matter how hard Attorney Hurley was working, or no matter what she believed or what her client believed, if the parties were out of contract, they're out of contract.
But it wasn't just them. It was also your client's representatives.
But respectfully, Your Honor, that does not put the parties back into contract once.
I see your point there, but what do you do with the fact that that the conduct was on both sides, not just one side, not just wishful thinking, as in a way you've put it?
I think the best way to answer that, Your Honor, is whatever actions had been engaged in by the attorneys to try to clear a title issue. On the seller side, it wouldn't necessarily be purposes solely of this deal. The seller at some point was going to want or need to have a title issue with his property corrected. And as to the buyer's side, the trial judge, after hearing from the witnesses, determined that there wasn't sufficient conduct by the parties that would vitiate the clear language of paragraph 27 that required an extension. So I think both on the formation issue and on the waiver / paragraph 27 issue, clear error has not been established. And finally, as to the power of attorney that brother counsel references, the fact that a seller gives a power of attorney to his attorney to sign documents on his behalf does not grant any further rights than what we had been talking to, because there had been no written modification to the agreement. And once again, the trial judge found that seller's attorney's conduct did not constitute a waiver. And as to the portion of my brother's brief that addressed specific performance, there was never a tender on the buyer's side, nor was there evidence, since this required a mortgage, that the buyer was ready, willing, and able to perform on any given day. I understand seller said he wasn't going to perform, so there wouldn't be a closing for the buyer to show up to. But the reasons I articulated, coupled with the analysis by the trial judge in his memo, I think dispenses with a specific performance argument. And I will, for that, unless your honors have questions.
Am I remembering incorrectly, but didn't the judge make a finding that the buyer was ready, willing, and able?
I can double check that quickly, your honor, if I might.
It's, no, I wanted to be sure I heard what your argument was, but I can go back and look.
I think the way the judge handled that was at the end of his decision, parties never agreed on a set closing date. Plaintiffs not entitled to specific performance under the facts of this case, and being ready, willing, and able to some extent requires a date by which you would perform, and that was not agreed upon.
Next.
And once again, I would rest on that unless your honors have additional questions.
Check with the panel. I see no additional questions, so thank you both very much. We'll take the case under advisement. Wish you both a very happy and healthy Thanksgiving holiday, and we'll get an answer to you as soon as we can.
You as well. Thank you, your honors.
Thank you very much.